You may be seated in any seat. Come on in, ladies and gentlemen, make yourself comfortable. Everyone should have a seat. Come on in, ladies and gentlemen, make yourself comfortable. All right, lawyers and parties, you may be seated. Deputy Garrett, if you would.
Neil Broom, Neil Broom.
He's with you.
Thank you, Your Honor.
You're welcome.
Mr. Broom, how are you employed, please, sir?
I am the Laboratory Director and President of Technical Resource Center.
What is Technical Resource Center?
Technical Resource Center is a computer forensics laboratory. I have one lab that is located in Atlanta, one lab that is located in Los Angeles, and we do computer forensics and digital investigations on computers and cell phones.
Okay. Please tell us your background in preparation for your current position, sir.
Certainly. I was a law enforcement officer in Gainesville, Florida for 5 years. I then moved to Atlanta and got in the IT field, worked for the company that invented internet banking, worked for a company teaching internet security to organizations such as the CIA and the National Security Agency and the FBI. I then worked for a company doing training in those same fields. I had then decided that I would look for what the next big thing is in security and in IT. Found the forensics arena before it was a big thing, before people knew what it was, and wrote a book in the field called Computer Forensics Jumpstart.
That's what I was going to ask you. What was the name of the book?
And it now has 2 volumes. That is used as a textbook at certain colleges around the country. When I was teaching classes, I have trained over 3,000 people in the field of computer security and digital forensics. I quit counting at 3,000. I can skip ahead to a couple questions to save time. I have a multitude of certifications in the field. I am a certified computer examiner, a certified fraud examiner, a certified information systems security professional, and a certified hacking forensics instructor. I actually can teach those classes.
Mr. Broom, can you tell us, sir, whether or not you have ever been qualified as an expert in a state court or as a federal court as an expert in digital forensics, sir?
Yes, sir, I have. I've been declared an expert in both federal and state court in both criminal and civil cases.
Have you actually testified in court as opposed to giving an expert deposition, sir?
Yes, sir, I have. And
for the benefit of the ladies and gentlemen of the jury, can you tell me what is a deposition?
Certainly. A deposition is a meeting ahead of time before it's in front of a jury or in front of the judge, where the attorneys get to ask all kinds of fun questions to the expert, and it's sworn testimony, and the expert has to answer those questions truthfully, and it saves time for later when it's time to go to court.
So you have done both?
Many times for the deposition, sir.
Now, have you ever served in the function of editing, technically editing any publication, sir?
Yes, sir. In addition to writing as a co-author for a couple books, I was also the technical editor for other people's work on computer forensics books.
Okay. What is involved in digital forensics on a day-to-day basis, sir?
Okay. The basics of digital forensics is that you have some type of electronic device, be that a computer, a cell phone, a Blackberry device, a GPS device that you want to look at, but the way we look at it is in a way that is different from the way the user looks at it. For instance, if you turn on your computer, you're looking at data based on what the operating system is allowing you to look at. The way we look at it forensically, on the other hand, is we look beyond that level. We look down at the basic data on the hard drive and we ignore what the operating system is telling us, and we look and see the actual data that's still available on the drive. One of the key tenets of forensics is we try not to ever work on the original evidence. We work on a forensics copy of the evidence. So the very first step that we do in forensics is we retrieve the evidence, prepare a chain of custody of that evidence, and then make a copy of that evidence and actually prepare a chain of custody of the copy. And that chain of custody stays with that evidence throughout the life cycle of the evidence to show who was in possession of that evidence each step of the way.
Now, tell us about whether or not you currently or previously have ever served on any committees with any international or national organizations, sir?
Certainly. I am currently on a committee for the organization that controls the CCE certification, the Certified Computer Examiner. I'm on the Ethical Standards Committee for that group.
Have you previously served on any committees or any leadership position for the American Society of Digital Forensics and E-Discovery?
Yes, sir. I was their LA chapter president.
Okay. And have you ever received any awards from the CCE or Certified Computer Examiner organization, sir?
Yes, sir. I believe it was spring of 2009. I received an award from that organization for my service to the organization.
Okay. Your Honor, at this time, I would move to qualify Mr. Broom as an expert in the field of digital forensics examination.
Whose witness is this?
It's mine, Your Honor. No objection.
All right, he'll be considered as an expert in his field.
Thank you very much, Your Honor.
You're quite welcome.
Now, Mr. Broom, in the case that we are talking about here, the case of the State versus Andrea Sneiderman, did you, in your capacity as a digital forensics examiner, and let me back up. In addition to the technical qualifications you have just given us, do you have any other hats that you wear?
Yes, sir. One, I'm a licensed private investigator, both in the state of Georgia and the state of California, and I am the laboratory director of an accredited crime lab. The Technical Resource Center is the only accredited crime lab in the state of Georgia, and that is both private and governmental. There are no other agencies that have a accredited crime lab in the field of digital evidence computer forensics.
And if I remember correctly, the GBI crime lab has certain divisions that are accredited, but the computer forensics is not. Is that what you're saying?
Absolutely, sir. They have many other disciplines in which they've earned accreditation, but not in the field of digital forensics.
Okay. Yours is the only one in Georgia?
The only one in Georgia, yes, sir.
Okay. Now, can you tell us, Mr. Broom, whether or not in this case you had occasion to review, first of all, just lots and lots of telephone records?
Yes, sir, I did.
Did you receive, as evidence in this case for you to review, the cell phone records, including cell tower locations, for a telephone number identified as being that of Andrea Sneiderman?
Yes, sir, I did.
Did you also receive the cell phone records from a telephone identified as being the cell phone of Hemi Newman?
Yes, sir.
Did you also receive records identified as the home telephone records for Andrea and Rusty Sneiderman?
Yes, sir.
Your Honor, at this time I would tender into evidence Defendant's Exhibit number 48, which I have previously shown Ms. Cross, which is the records provided by AT&T for the home telephone of Rusty and Andrea Sneiderman.
Any objection, 48?
Based on Mr. Petrie's affirmation that they are, in fact, the complete records, the state has no objection.
The only thing missing is the cover page that had some details that I don't think are pertinent to this case, Your Honor. Everything else is here, so I will represent that.
All right, I mean, but at this point, I'm viewing that as the state has no objection to 48.
No objection, Your Honor.
All right, it's submitted without objection. You may approach to the jury. Yes, sir, you may approach.
You don't need to look at those right now, just get them out of my way. Now, in your review of the evidence in this case, Mr. Brown, did you have occasion, sir, to, not necessarily connected specifically with this case, but did you have the occasion to review those records and make a determination as to the frequency or use by, by Mrs. Sneiderman of texting?
Yes, sir, I did.
And tell us what your analysis revealed to you.
The easiest way to say it is Mrs. Sneiderman is a textaholic. She had very, very many text messages that she utilized.
Okay. Now,
You got to take that out the screen for right now.
oh yes, we're not there
That
yet.
has not been omitted. Please. Thank you.
Were you able in addition to making the, I guess texaholic is not a technical term.
No, sir, it's not.
It's a private investigator term. Did you have an occasion and were you asked to analyze the monthly phone or text analysis between Mrs. Sneiderman and Hemi Newman between May of 2010 and November of 2010, sir?
Yes, sir.
Okay. And would that include both calls from Mrs. Sneiderman to Mr. Newman and vice versa?
Yes, sir.
Would that include text from Mrs. Sneiderman to Mr. Newman and vice versa?
Yes, sir.
Did you also, sir, have the occasion to analyze the phone calls and text messages, the communications or contacts between Andrea Sneiderman and her husband, Rusty Sneiderman?
Yes, sir.
Did you have occasion to review both the calls from Mrs. Sneiderman to Rusty and from Rusty to Andrea?
Yes, sir.
Did you have occasion to analyze the text from Rusty to Andrea Sneiderman and from Andrea Sneiderman to Rusty Sneiderman?
Yes, sir.
Now, in your analysis, did you limit yourself to Mr. Sneiderman, that is Rusty Sneiderman's cell phone, sir?
No, sir.
Did you include the contacts, and I guess one doesn't text a home phone, right?
That is correct,
So
sir.
it's just all calls.
Yes, sir.
Did you include in your analysis then the calls or contacts between Mrs. Sneiderman's cell phone and the home phone?
Yes, sir. In addition to Mrs. Sneiderman's cell phone, we also included her work phones calling her home phone.
Okay. Work phone calling her home phone, so Mrs. Sneiderman's landline work phone calling her home phone as well.
Correct.
I'm sorry, excuse me. I had an objection. I believe any work phones have been admitted into evidence, have they?
I'm sorry, I didn't hear. What's the objection? I didn't
The
hear.
objection is that the witnesses testify about evidence that has not, and I don't believe will be admitted into evidence.
Ms. Petrie?
Yeah. These
Response.
records, yes, sir. I think I can clear it up.
All right, I sustain the objection.
Was this analysis based on your evaluation of the home telephone records?
Correct. I was able to see the records of who called the home phone. I looked at the home phone records only.
You did not pull GE's landline records, but those calls are reflected in Defense Exhibit number 48.
That is correct.
I believe it would be admissible under that, Your Honor.
I mean, there's no objection at this point. I'm only
Oh, okay.
responding to the
I
objection.
just thought she was standing up behind me, waiting to
No,
waiting to pound.
no, she didn't stand up.
Okay, thank you, sir. Now, Mr. Broom, at my request, did you do I'm not sure whether analysis, a review of certain telephone calls made on October the 22nd, 2010 from Mrs. Sneiderman's, from or to Mrs. Sneiderman's cell phone?
Yes, sir.
Now, insofar as actually whether she was in Atlanta or Greenville or Timbuktu on that day, you have no personal knowledge, correct?
That is absolutely correct.
This analysis is based on your review of the records that were provided through the AT&T Mobility folks. Is that right?
That's correct.
Now, at my request also, did you review the telephone records of Mr. Newman to determine whether or not there had been any communication between a certain number identified as that belonging to Melanie White and Hemi Newman on October the 22nd, 2010?
Yes, sir, I did.
And did you, at my request, also analyze to determine whether or not there had been any calls between Melanie White and Hemi Newman's cell phone on August the 26th of 2010?
Yes, sir.
And at my request, additionally, did you analyze whether or not in the month of December 2010 there were any telephone calls or text between Hemi Newman and Melanie White?
Yes, sir, I did.
And again, you were not analyzing records from Melanie White. This analysis came from a review of the materials identified as being the cell phone records for Mr. Newman. Is that correct?
That's correct.
Now, Ms. Petrie, let me, for clarification, you're saying he did not look at any records from Ms. White?
He did not look at her records. Her calls to and from and texts to and from Mr. Newman were gleaned from a review of Mr. Newman's records as opposed to a separate analysis of hers.
I understand. Go ahead.
Your Honor, at this time, I would ask permission first of all, I guess I better introduce these, and these are just demonstrative.
You may.
May I approach?
Yes, sir.
Mr. Broom, I'm going to ask you if you would look at defendants 49 through 54 and tell the court and the ladies and gentlemen of the jury whether or not you can identify those, sir.
Yes, sir.
And are they, in fact, demonstrative aids displaying or demonstrating some of the analysis that you did in this case?
Yes, sir.
Would the use of these slides be of assistance to you in testifying before the jury and explaining what your analysis revealed?
Yes, sir.
Your Honor, at this time, I would tender into evidence that this is for demonstrative purposes only. Defendant's exhibit number 49 through, I want to say 54.
Any objection, 49 to 54?
No, Your Honor.
All right, 49 to 54 be admitted without objection. You may call them to the jury.
Okay. Mr. Williams, if you could, Mr. Broom, you may be able to see these on the screen, but I'm going to ask you to let me know if you cannot read them from there. I'll give you a hard copy, please.
I can see just fine, sir.
Okay. And this is, Your Honor, this is identified, the copy I will submit to the court as defendant's exhibit number 49.
Yes, sir.
Mr. Broom, would you please explain what this slide contains?
Certainly. It's from the AT&T call records for Mrs. Sneiderman's phone, and it details her texting in the months of February through August 2012. The reason why it is 2012 is because the records didn't go back prior to that.
Okay. And in order to get records for a particular time that are with the call details, they are deleted over time by the actual carrier, is that right?
That's my understanding. I don't have firsthand knowledge of what the carrier does, but yes, they're not available to me.
And just make sure, these defendants exhibit 49 doesn't show really any text or calls directly involved in this case, is that correct?
Because of the time frame, absolutely not.
It displays simply Mrs. Sneiderman's proclivity for texting, is that correct?
Correct. And one thing to point out on the slide is simply the bottom of the slide that shows that she was arrested on August 1st, so therefore the month of August was much shorter than the other months.
Okay.
A much lower number of texts.
So that's July the 19th through August the 1st, although the billing circle may have been July the 19th to August the 18th.
Exactly.
Okay. Now, if I could direct your attention to defense exhibit number 50. And what does this show us, please, sir?
Certainly. While it looks a little bit complicated, it's actually a very simple analysis. These are the records of communications from Hemi Newman's cell phone.
Okay. And can you be more specific?
Certainly. In the year 2010, we have May through November's text messages to and from Hemi Newman and call records to and from Hemi's cell phone or work number based on the AT&T call records.
And when you say text messages or calls to or from Hemi Newman, you're directing that specifically to Mrs. Sneiderman? Or, I mean, is this every text message, every call he got, or is this just a contact with Mrs.
I apologize. Yes, this is to and from Hemi Newman and Mrs. Sneiderman.
Okay. The slide doesn't say that, but that's what it is?
Correct.
Okay. If I could, what was the total number of text, please, sir, between Mrs. Sneiderman and Mr. Newman between May and November of 2010?
Certainly. The total number of texts was 1,185. The total number of calls was 247. I used the term in quotes contacts here of 1,432 contacts. The reference to the word contacts I took from the trial of Hemi Newman, where the state presented evidence.
Objection, Your Honor.
I'm going to sustain that objection. Would you like to rephrase your question?
Is that based on previous testimony relating to an associated matter and the terminology that was used in that previous trial? Is that why you chose this term here?
Exactly. I just wanted to carry over with the same terminology that was used previously, so we wouldn't be comparing apples and oranges at a later date.
So you call contacts what you believe had been called contacts before?
Yes, sir, which was a combination of both text messages and phone calls.
Okay. Thank you, sir. If we could show defendant's exhibit number 51.
You may.
Now, Mr. Broom, can you tell us what this is? It appears similar to the previous slide in its format, but what does this show us, please, sir?
Certainly. Tried to make it as similar as possible, so again, we can compare oranges with oranges. What we have here is the phone calls and text between Mrs. Sneiderman and her husband, Rusty.
Okay. Now,
I'm going to object to that, Your Honor. I think that I think the testimony was that that was to the home phone line, not necessarily Mr. Sneiderman.
Okay, that's fair enough, Your Honor. You don't know who actually participated in that phone call, correct?
That is absolutely correct.
But, so when it says calls from Rusty Cell at Home, calls to Rusty Cell at Home, that is actually calls to those phones, you don't know what was the nature of the conversations.
I stand corrected.
So
All right, go ahead.
we'll proceed, Your Honor. Between May and November of 2010, how many texts to or from Rusty's phone and Mrs. Sneiderman's phone were exchanged?
83 text messages?
Okay. Now, what about calls to or from Mrs. Sneiderman's cell phone and her home phone number or her husband's cell phone number, sir?
1,021.
Okay. So the total number of, as you said, contacts between Mrs. Sneiderman's cell phone and either her husband's cell phone or their home number during that time was what number, please, sir?
1,104.
Okay. If I could direct your attention, please, sir, to Defendant's Exhibit 52. What does this portray, sir?
Certainly. What we have on the left side of the screen is the numbers that were provided to us from Hemi Newman's trial by the state of the number of, again, contacts between Mrs. Sneiderman and Hemi Newman and Mrs. Sneiderman and Rusty.
Okay. Go ahead.
Between Mrs. Sneiderman and Hemi Newman, the state said there were 1,426 contacts. With Mr. Newman, with Rusty,
I object to the comparison to testimony in a previous trial.
Feature.
Your Honor, this is the data that was produced for him, and he reviewed that testimony. Obviously, with the court's ruling, he was not able to participate or to listen in to what the witness testified in this trial. However, if I may have one moment to speak with Ms. Cross.
You may.
I think I can convolutedly change this, then, Your Honor. Assuming hypothetically, Mr. Broom, that the testimony in this trial was the same and that there were 1,426 contacts with Mr. Newman, would that change the data that you have in Defense Exhibit number 52, sir?
no, sir, it's the same.
And the contacts with Rusty, again, assume that the testimony in this trial previously from other witnesses was that the total number of contacts with Rusty was 882. Would that change the data that is included in Defense Exhibit number 52?
No, sir.
Now, the data on the right, the one that's labeled actual numbers include cell and home phone contacts. This is based on your own analysis. Is that correct?
Yes, sir.
Now, how many contacts, that is either text messages or phone calls, were you able to recover between Mrs. Sneiderman's cell phone and Mr. Newman's cell phone?
We actually discovered more than the state discovered, 1,432.
Okay. And what about contacts with, and again, this says contacts with Rusty, but again, you're talking about his cell phone and their home phone number. How many contacts between Mrs. Sneiderman's cell phone and her husband's cell phone or their home number?
1,104. The difference being between my number and the state's number, hypothetically, is that the home phone records are included in my analysis. They were excluded.
I would like to direct your attention, sir, please, to Defendant's Exhibit number 53. Oops,
Can you go back to the previous slide, sir?
Can you go back to the previous slide, please? Oh, already there.
Yes, sir. There's one important statement to make about this slide, and that is the term contacts that I've alluded to a couple times is a false definition. What was given as a number...
I'm going to object to this. This was not in response to a question.
Sustained.
Okay.
Next question, Mr. Petrie.
Yes, sir. Mr. Broom, does, in the term contacts as used in your testimony and your presentation here today, is a text message that would simply say later or yes or okay, is that counted as a contact just as much as a 15, 20, 30-minute phone call would be?
In the state's analysis, hypothetically, yes, they would count exactly the same. Of course, saying yes in a text message and speaking to your husband for 20 minutes.
Okay.
Your
That
Honor.
was a sustained that objection. You want to rephrase that question?
Yeah. So there was no qualitative analysis performed as to what is said in a text message, whether it be, well, what is it? Max is what, 140 characters? Something. In a text message, it's sort of short,
No,
right?
No, no.
My daughter would know. So a yes, no, later text message and a 5, 10, 20-minute phone call conversation, each one of them counts as, quote, a contact.
Yes, sir.
Okay. Thank you, sir. Now can we have, please, Defendant's Exhibit number 53?
Is there a maximum on text messages? The maximum characters?
There is, and then it carries over to the next message. So if
So there's
you,
no max?
depending on your device, it would either, you would have a certain level and then another length and another message. Well, I think what Mr. Peter was referring to was
Well,
tweets.
I want to ask you. I was asking,
Tweet?
was there a maximum?
I don't know nothing about no tweets. We're staying away from
Why
tweets.
not? You didn't ask him about tweets.
Yes.
I mean, you asked,
Okay.
that's why I asked the question for clarification. There's a difference between tweets and what you're talking about. So, but you didn't mention tweets there just now.
And, Your Honor, we're approaching the outer limits of my technical knowledge, so we'll move to the next slide.
Go right ahead, Mr. Speaker.
Thank you, sir. What does Defendant's Exhibit number 53 show, Mr. Broom?
You previously asked me if indeed you'd ask me to show communications on October 22nd, 2010, concerning a business trip to Greenville. This is simply we pulled out of the call logs communications that occurred in the morning of October 22nd, 2010. The first line in yellow equates to the first bullet below. So in other words, at 7:54 a.m., there was a phone call between Rusty between the Sneiderman's home telephone and Mrs. Sneiderman's cell phone. There was simply a voicemail that was left.
Okay.
At 8:06, Mrs. Sneiderman retrieved that voicemail message. And then at 8:08, Mrs. Sneiderman called and spoke to the home phone for 5 minutes and 46 seconds.
And then the next lines, please, sir.
Those lines are showing that at 8:13, Hemi Newman and Mrs. Sneiderman, Mr. Newman left a voicemail for Mrs. Sneiderman, and then at 8:14, Mrs. Sneiderman returned the phone call to Mr. Newman.
And all of these calls or phone messages took place between 7:54 and 8:14, so about a 20-minute span on the morning of October the 22nd.
Yes, sir.
And even though the slide itself says communication summary during Greenville business trip, you have no personal knowledge whether or not there was a Greenville business trip at that time, correct?
Correct.
I just asked you to prepare a slide for those phones. That's all you reviewed.
That's correct.
Now, if we could draw your attention, please, sir, to Defense Exhibit 54. Did I request for you to look to determine whether or not, with the telephone number provided for Melanie White and the number that you knew as Hemi Newman's cell phone number, to look and see whether or not in the October the 20th, 2010 area, there were any phone calls between Melanie White's cell phone and Hemi Newman's?
You requested that, yes, sir.
And what did you discover?
There were no phone calls on the October trip.
And did I ask you to make a similar analysis for the August the 26th date? And again, you don't know whether anybody was in Greenville or not, though, correct?
Correct.
Did you, in fact, find any calls between Hemi Newman's cellular number and Melanie White's cellular number on August the 26th?
Yes, sir, I did. There was one contact.
And when was that, sir?
At 10 a.m. on the 26th of August, 2010, and it was for 2 minutes and 38 seconds.
Did I request that you review to determine whether or not there were any calls or texts between Hemi Newman and Melanie White's number in the month of December 2010, sir?
Yes, sir.
And what did that analysis reveal to you, sir?
That there were 24 telephone calls and 31 text messages between Hemi Newman and Melanie White, and that each of those text messages had been deleted.
Now,
Now, let me just ask a question. They were deleted from the Newman's phone number that's assigned to Mr. Newman, is that correct?
Correct, sir.
Because you said you did not do an analysis of Ms. White's phone, is that correct?
That is correct. These were this was an analysis of Mr. Newman's cell phone.
Well, the phone number that's assigned to him.
Yes, sir, more correct.
Go ahead, Mr. Speaker.
thank you. Now, Mr. Broom, were you requested in this case also to assist in analyzing an item of evidence, a Blackberry smartphone.
Yes, sir.
Tell us how that got started with you.
I was informed that one of the charges against the defendant,
Objection, Your Honor, hearsay.
I'm going to sustain that objection. As far as the way you asked the question, he could give you a response without relaying a quote-unquote hearsay response. So, Mr. Witness, if you could, listen to the question Mr. Petrie asked and answer his question.
yes, sir.
At some point earlier in this case, did you and I have a discussion regarding the nature of the charges in this case?
Of course, yes, sir.
And did you, in fact, and I discuss the specific charges against Mrs. Sneiderman?
Yes, sir.
Were you made aware, sir, that certain charges involved her allegedly?
Your Honor, I'm going to object. What the witness did and what he can testify to is to analysis is relevant. The context in which it was phrased for him, I think, is irrelevant and is hearsay.
I don't believe it's irrelevant, Your Honor, because it informs the.
I know. Lawyers, approach for a minute.
Nope. Hey, good morning, everyone. I'm Jeff Hullinger, along with attorney Zara Karanchak. She is with us, a former federal prosecutor, a defense attorney, a graduate of the Emory Law School. We are seeing the attorneys come to the judge right now. This is a short session. Can you give me a sense of what is going on right now?
Well, they're talking about how this witness's testimony is being presented in court, and the prosecutors brought up that she thinks the testimony is not relevant. So this could be critical for the use of this expert. And as you and I were talking, the testimony of the expert is not really clear where they're going with this, but I think the judge is probably going to give them some direction on how much leeway he's going to give with the questions that the defense attorney is asking right now.
I think the question that certainly a lot of people have right now is how many more defense witnesses will we see on this Thursday, and when will we hear from the defendant as to whether she will take the witness stand? That's one of the searing questions of the day that we're just going to have to ride out and see how it plays.
I agree.
So here we are. This is day 9, and there have also been questions about when the jury will receive this case. If Andrea Sneiderman does not testify, the conventional wisdom among a lot of attorneys seems to be that they could get it by tomorrow. If not, then it could go into next week, week 4.
And that would depend on the judge, how much time he wants to give them to prepare their closings, because some judges, particularly if one of the parties asks for it, they'll wait and give them the weekend to prepare, and they could do closings on Monday.
I see. All right, back into the courtroom right now, and Judge Adams.
About the charges in the case, did you, in fact, begin the process of gaining access to at least a copy of the Blackberry in this case so that you could perform your independent analysis?
Yes, sir.
Okay. Please tell the court and the ladies and gentlemen of the jury what you were provided with, sir.
I was provided what was purported to be a copy of Andrea Sneiderman's GE Blackberry device, which is a Blackberry 9700 Bold.
And when you say a copy, they didn't furnish you with a clone phone like hers. You got a digital copy of the information from that phone. Is that correct?
I received a file that I was told was an image of the phone that did not contain paperwork showing exactly what it was an image of.
Okay.
That's why I cannot be more specific to say what it was. I can only say what I was told it was, but there was not what I would consider the correct paperwork that would forensically validate an image that was made.
Okay. Tell us, let me back up just a second there. When you say that there was not the associated paperwork, when you use the phrase chain of custody, what is involved there?
Certainly. It's not as complicated as it sounds. It's simply a piece of paper that lists any item of evidence, make, model, and serial number of a phone, for instance, and then the date, the person's name who gives it to you, and the person's name who receives it, and each person signs the form. It's that simple. If the item of evidence then transfers to another person, let's say from the original officer that took it at the scene to a lab for analysis, the officer would sign as the person releasing the evidence, the person he gives it to would sign as receiving the evidence, and then it would simply have a comment section that said, transferred for processing. So it's just a chain of showing who was touching an item of evidence, who was responsible for that item of evidence, and to show that each person along the way was responsible for it. It wasn't just sitting on somebody's desk for months at a time. It wasn't sitting in a closet. It was under the care and custody of a particular individual for each step of the way, from the time it's seized till the time it shows up in court.
And did you request that documentation in this case, sir?
Multiple times, yes, sir.
And I believe you stated that you had to work on faith that the copy you got was in fact a copy of what it was supposed to be.
Correct. I never received a complete chain of custody for the actual device itself, which is one item of evidence, nor did I receive the chain of custody for the copy that was made. Again, I was told that a forensics copy had been made of the Blackberry. The copy now becomes an item of evidence itself. So there should be two chain of custodies if indeed they made a forensics image was made.
Now, can you tell us, once you got that copy, in general, what steps are taken at technical resource centers to analyze the contents of that copy, sir?
So we have a number of forensics tools that allow us to input that copy of the evidence into our tools, and then we can analyze it for SMS text messages, for email messages, for telephone calls that were made, depending on the device, photographs, even videos that were included on the device, web surfing history, if you use your web browser to surf on a smartphone. All of that's included in a report that we are able to generate from a multitude of tools that we have available.
What types of tools are you talking about? Do you use other computers? Do you hook it up to a little small machine, a big machine? What types of equipment are you using there?
Certainly. In this case, since we were provided an image, we only had to use one of our forensics computers running multiple versions of different software. For instance, one of the tools we used is known as Celebrite. We process
Spell that, please, for the court.
Cellebrite. And Celebrite has two components to it. They have a physical piece of hardware that you use to plug phones into it to make an image. And then they also have an analysis piece of software that simply runs on one of our high-end computers that we use to process. So we took the image that was already made, because I didn't have the phone anymore, and put that image into onto our computer, processed it in their software, and it presented very easy to read reports that showed all the evidence I just spoke of.
Now, Mr. Broom, did you follow the standard operating procedures in analyzing the copy of the Blackberry, or what was purported to be the copy of the Blackberry in this case, sir?
Yes, sir.
Were you able to get results? That is, were you able to find files, whether they had been deleted or not, or at least some that had been deleted in your examination of the Blackberry, sir?
Yes, sir.
And how does that work? How, if I delete something from my phone, how does a forensic examiner later recover what has been, quote, deleted?
Certainly. Early on in my testimony, I explained that we ignore what the operating system gives us, and we actually look at the device itself. If it's a computer, we look at the hard drive. If it's a phone, we look at the memory that's on the device. And even if something is deleted by the operating system, there are still remnants of it on the device up until the point that it is physically overwritten with new data. The bigger the device, the less chance it has to be overwritten with new data.
Is there anything about Blackberries in general, or about this model of Blackberry in particular, that is different from the analysis of either other cell phones or computers that you talked about?
Yes, sir, there is.
What is that? What are those differences, mostly?
Blackberry, a Blackberry device has a much lower amount of memory than, say, an iPhone. And because it has a lower amount of memory, it can't store as much information. And so if it runs out of storage, it would not be able to give you your new messages or your new emails, or even make new copies of your call logs. So to compensate for that, BlackBerry has an automatic system in their phones to delete text messages, email messages, calendar entries, and call logs.
Explain that deletion process to us. Is that something that is immutable, or can the user himself or herself change that or override that?
Certainly. By default, the overwrite time, the time to save a message up until, is 30 days. After 30 days, the messages can all be deleted at any time the phone chooses to do so to free up memory. The only exception to that would be as if you saved a message. So you potentially could have an old message that was saved, new messages be deleted because they weren't saved. And again, that's an automatic feature that's on the BlackBerry. It's settable by the user. You have a choice of setting it to automatically delete every 15 days, 30 days, 2 months, 3 months, 4 months, or forever. But out of the box, it is set for 30 days.
Now, when you said that a message or email or call, I guess, can be saved, how is that done on a BlackBerry?
There's actually a setting that says save in a message.
Okay, so
It's as simple as pressing a couple buttons and say save message.
now what would happen, Mr. Broom, if a message, say from January the 1st is saved, then forgotten about, then later you're coming up on the 30 days or 60 days or 90 days or whatever it is, would that message, even though it's older than either the default or the set deletion date, would it still be saved?
Yes, sir, it would be saved.
So if a message were retrieved from this BlackBerry going back to September of 2010, is there any way that you can tell from your analysis of what was given to you in this case, whether or not that message was just left on there by accident, at random, by mistake, or that someone had saved that message?
No, sir. It's just still there.
Now, with the BlackBerry, I think in speaking with you earlier, you had mentioned the phrase to me, first in, first out.
Yes, sir.
What is meant by that, sir?
Very simple. The first message to come in would be the first message to be deleted if the BlackBerry needed to free up memory space. I already mentioned that a BlackBerry has a limited amount of memory. Each time you run any application, like you start up a new game, you start up your messaging program, you start up an accounting program on the phone, any of those little things that you start up, each require a certain amount of memory to run. They require memory to be on your phone to begin with, but then when they're running, they require memory to run. Well, if you've got a whole bunch of applications open, even though we have that automatic deletion at 30 days, the phone can say, wait, I'm running out of memory. I need to go delete some old stuff, and it will delete that stuff even if it hasn't been 30 days yet. So the more stuff that runs, the faster stuff gets deleted out of the phone. The only exception to that would be is if you saved something like we discussed earlier. So an old message could still be there even though new stuff had been overwritten. And again, the first in, first out is simply the order that it attempts to get rid of the old stuff. First thing in gives the first thing gets deleted if possible.
Mr. Broom, were you able in your analysis of the image of the BlackBerry, were you able to recover previously deleted data from that image, sir?
Yes, sir.
Can you tell us what you were able to recover?
Numerous messages in and out of the BlackBerry device.
Okay. Do you remember approximately how many messages you were able to recover, or an exact number if you remember?
Oh, I do not have an exact number, no, sir.
Okay. Can you give us an approximate number of how many you were able to recover?
No, sir.
Okay. Was it more than a dozen?
More than a dozen, less than 1,000.
Okay. Okay. More than 100?
More than 12 to...
I'll say 200, and that will be about as precise as I could be.
Okay. Now, did you actually review those text messages for content?
I did.
And the content was the content of those text messages made part of the report you produced in this case?
Yes, sir.
Now, with the BlackBerry in this case, are you aware through the reports provided by the FBI as to what type of analysis, what type of procedures were utilized by the FBI in originally extracting evidence from this BlackBerry, sir?
I believe so, that I can interpret what was written in the reports, yes, sir.
And what is that, sir?
I kind of have to cover a little bit of groundwork to get to what they did because they did not do what would be considered a first step. They went beyond that. So can I have some leeway to give a background?
Oh, yeah, well, let's assume in this case that the testimony previously has been that whether or not a password was furnished to anybody, the FBI did not have a password.
Okay.
So does the fact that the analyst innocently or negligently or in good faith or whatever doesn't have a password, what type of analysis did the FBI do in this case?
Certainly. In the case of not having a password on a BlackBerry device, it's different for other types of devices, but on a BlackBerry, if you don't have a password, you cannot use the easier traditional cell phone forensics tools. You must go to a more intrusive analysis of the phone. It is commonly referred to as chip-off forensics. You actually have to perform destructive forensics. You have to actually take apart the phone, remove the memory chips from the phone, and process those memory chips. Of course, at that point in time, the phone never works again. So that's why I say it's a destructive process. It's a one-time thing that you get to do.
Your Honor, at this time, I would tender Defense Exhibit number 54, which was provided by the state to us.
You say D54?
D54, Judge?
But yeah, 54 already.
This is going to be 55.
Yes, sir, that'd be 55.
This is going to be 55.
Yes,
Thank
sir, D55. Yes, sir, you may approach.
you. Okay. Mr. Broom, I'm going to ask you to open Defense Exhibit 55, and I don't believe you've seen that before, so just take a moment and examine it, sir.
I'm going to put my evidence away here.
Don't steal any of the introduced.
Okay, sir.
Okay, have you had a chance to examine the contents of Defense Exhibit number 55, sir?
I have.
And can you tell us what Defense Exhibit number 55 contains, sir?
This is a BlackBerry Bold 9700. In this bag, we have a SIM card for the phone that allows it to connect to AT&T's network. We have a micro SD card, which would be data storage. It's very small. And then in this bag, we actually have the memory off of the phone itself, the processing chip of the phone.
Now, if you had the right kind of soldering irons or tweezers or whatever you need, could that phone be used again?
No, sir.
And why is that?
Once the processing memory gets removed, it's over. This can't be put back.
Okay. Now, is there any way, Mr. Broom, that from the data disk that you got, the image that you got, or from an examination of Defense Exhibit number 55, is there any way that you or another forensic analyst can tell us what the setting was for the deletion date on Mrs. Sneiderman's BlackBerry?
No, sir.
Can you tell us, either from your analysis of the image or from examination, or could someone from the examination of the BlackBerry tell us when anything was deleted from that BlackBerry?
No, sir. When a text message gets deleted, it is deleted. It's potentially recoverable, but we do not have the date of when it was deleted. We just know it's deleted.
So a text message that I send on January the 1st, I delete it. If somehow you're able to recover it later, would your recovery include the fact that I sent it on the 1st?
That's what it would include, yes, sir.
Or received it on the 1st?
Correct.
But if I deleted it on the 2nd, that information would not be there, is that correct?
Correct. If you deleted on the 2nd, the 3rd, the 4th, I would have no idea.
Now, Mr. Broom, in your analysis of the information, the BlackBerry itself and the image from the BlackBerry, is there any way that you can tell whether or not Andrea or anybody else can tell whether or not Andrea Sneiderman deleted anything off that BlackBerry from November the 18th up until today, November the 18th, 2010, up until today?
In the computer forensics field, we have kind of a funny saying, and that is, we cannot put the butt in the seat or hands on the keyboard. In other words, all we can say is something was deleted, but we can never say who did the act unless there was a witness or a video camera on the person that did it.
can you even tell through your analysis whether or not anything was deleted by a user, either purposefully or negligently or just accidentally, as opposed to auto-delete?
No, sir, there's no difference between the two as far as the way the evidence shows now.
Can you tell from any analysis of the actual telephone at this point or the data, the image provided, as to whether or not the auto-delete default setting of 30 days was ever changed on that telephone?
I cannot tell that, and one of the problems with that is that, let's say it was set today at forever. Don't ever get rid of anything. I have no idea what it was set for yesterday. Yesterday it could have been delete in 15 days. And therefore, whatever it was set in the past, all we would have is what it is currently set with today. And I'm talking about a phone that I could actually start up and look at today. I only have today's setting. I would not have a historical setting. So over time, how it was set up could have changed. So even if it was set to retain forever now, we don't know that it was always set that way. The default out of the box is 30 days.
Now, Mr. Broom, you are aware, I believe, from the previous reports that I furnished to you that Mr. Mike Fisher from the FBI in Quantico did what you call the chip-off analysis in this case, correct?
Yes, sir.
And then the report of that was returned to Mr. Fryman here at the Atlanta branch of the FBI.
That's my understanding, yes, sir.
Did any of their reports, any of the documentation that you received from them inform you as to whether or not they or anybody else from the DA's office, the Dunwoody Police Department, the GDI, or the FBI had ever looked at that phone to see whether or not the auto-delete default of 30 days was set on that phone?
I saw no indication of anybody ever examining that.
Assume that there was testimony that the cell phone was turned over to the DeKalb County District Attorney's Office sometime in the late winter or early spring, sometime late February to mid-March of 2011, and was ultimately taken to the FBI, I believe, in the spring of 2012.
Okay, sir.
Is there any way that you or another analyst can look at the data retrieved from that telephone or the phone itself and say, aha, this deletion occurred during this period when it was in Mrs. Sneiderman's possession, this deletion occurred when it happened when it was in the DA's possession, this deletion occurred when Mr. Fisher had it, this deletion occurred when Mr. Fryman had it?
I object to the phrasing of that question, Your Honor. I mean, the witness can testify as to what his opinion is, but asking him to comment on what other experts or other opinions might be, I think is improper.
I'm not asking what their opinion is, Your Honor. I'm asking whether or not he can tell or anyone can tell whether or not any of these deletions happened at any stage that we know this Blackberry went through. So I'm not asking him what Mr.
I don't have
Fryman...
an objection to
When you
that
say,
question.
but wouldn't somebody else be in the anybody category? You understand what I'm saying? I mean, you're saying not that it's him, but anybody.
Well, we don't, without the chain of custody, Your Honor, we don't know whose possession this Blackberry was.
Well, I understand
I'm
your
mentioning the only names they gave us.
Well, I understand your argument. I'm gonna sustain the objection. I'll let you rephrase it.
Okay. I mean, of all the people that documentation or reports indicate had possession of that Blackberry after Mr. Kirschenbaum turned it over to the DA's office back in 2011, is there any way that you or anyone else can tell that any deletions occurred during any of that time, sir?
No, sir.
The Blackberry itself, no one could analyze it again now, is that correct?
That is correct, sir.
So the only intelligible forensic evidence to come now would be from one of the copies, and all copies should be the same, correct?
That's correct.
And you have reviewed and analyzed that copy.
Yes, sir, I have.
To the best of your knowledge, did you have a copy of the same one that Mr. Fryman worked from, sir?
To the best of my knowledge, yes, but I do not have a way to absolutely verify that due to the lack of the chain of custody.
Now, the deleted information that you recovered from the image of the Blackberry itself, Mr. Broom, did you recover any message? You said you did review the content, correct?
Yes, sir.
Did you discover any text on there that the FBI were unable to recover?
Yes, sir.
Okay. And that was made part of your report?
Yes, sir.
Now, can you tell us whether or not in your analysis, and you can look at the, let me back that, it's going to be a really bad leading question. Can you look at the mobility cell records, the volumes that AT&T Mobility keeps showing the cell phone usage, either text messages or call records? Can you use those in comparison to what is found on the telephone and see essentially, here are types of things that have been deleted?
Yes, sir.
Can you tell the ladies and gentlemen of the jury, in your analysis in this case, was it only messages to and from Hemi Newman that were deleted from Andrea Sneiderman's Blackberry?
Oh, no. That's it. There were many messages deleted from multiple people.
And did you recover anything from November the 18th? Were there any messages recovered from her Blackberry for November the 18th that you recall?
No, sir.
And are you aware from the records on that date that there were quite a number of calls and texts from her cell phone on that date?
Absolutely. There were actually 100 phone calls made on that day.
Okay. To one person, two people, a variety of people?
A variety of people.
Now, in your capacity as a private investigator, Mr. Broom, once you were hired in this case, did you make an attempt to, looking at the phone records from Longmont, Colorado? You were asked to look at those, correct?
Yes, sir.
Did you make an attempt, sir, to determine whether or not any records were available for Hemi Newman from any other hotel or motel in the Longmont area?
I did, sir.
What efforts did you make? Don't go into what somebody else told you, but if you could just tell us what efforts you made.
No, I'm not objective. This looks like it's somewhat outside the witness's area of expertise.
He's a private investigator too, Your Honor.
Well, I'm not arguing the objection. I want to use my latitude to ask the question.
What did you do?
Certainly. One of the types of records that's available from AT&T are data records, meaning where your cell phone was connecting to send data, and it not talking about call logs or not talking about SMS, but other types of data on the phone. For instance, emails. That report for Mr. Newman's phone on the time that he was in Longmont, Colorado, I got a cell tower location that was located southeast of the city of Longmont, approximately 6 miles southeast at an intersection of Interstate 25 and Highway 52, well outside the city of Longmont. After I got that information, I decided to check that area to see if there were any hotels in that area. There were a dozen hotels located one exit north on Interstate 25. I then proceeded to call each of those hotels to see if Mr. Newman had a hotel reservation at any of those hotels for the period that was literally 3 years before my day of calling. As you can imagine, I got laughed at by hotel clerks trying to come up with records from 3 years before on a number of occasions.
So the bottom line is you didn't get anything.
I didn't get anything.
One moment, please, Your Honor.
You may. Take as much time as you need.
Your Honor, that's...
All right, Kelly, we're back on the
Oh,
record.
I'm sorry. I was
no
jumping
problem.
the gun there.
We're back on the record. Yes,
I
sir.
was simply stating, Your Honor, that I have no further questions at this time. Mr. Broom.
All right. Thank you, sir. Ladies and gentlemen, with the assistance of Deputy Garrett, actually it's time for your break. You've been going for about an hour. And I thought when you stood up, someone gave me the break signal also, so I can read the hand, I can still read your hand signal. It'll be 10 minutes. 10 minutes, Deputy Garrett. All rise.
And good morning, everybody. I'm Jeff Hullinger. Welcome to 11 Alive's continuing coverage of the trial.